Hello, everyone, and welcome to a new session with Rights and Responsibilities Awareness Initiative. Today, we have Manpreet Kaur to talk to us about a very important topic, slip and fall, what to expect. Very important topic, very common topic in Canada. Many of us got some personal experience with this. So thank you, Manpreet, for being here with us today.
You're very welcome. I'm glad to be here.
Thank you. So, Manpreet, the floor is yours now. What you can tell us about this important topic?
Well, first of all, good evening, everyone. I'm very happy to be having this opportunity to present and talk about slip and fall cases in Ontario. As you pointed out very rightly, this is a very common problem here in Canada. And so this should be a great informative presentation. At least that's what my hope is. My name is Manpreet Kaur Sachdev. I'm the founder and principal lawyer at Courageous Law. And my law firm is right here in Ontario, in London. I also have an office in the GTA in Mississauga. Primarily, my practice area, my focus is on personal injury law. So that's the kind of files that I usually handle. And this presentation is specifically about slip and fall cases in Ontario. And this is going to be a very general and basic information. So please keep in mind that this presentation is for educational purposes only. It's important to understand that this presentation cannot be substituted for tailored legal advice. The nature of information that I'm presenting here is basic and general, as I said, and I do understand that there is going to be a Q&A session in the end. However, because this is a public platform, I would urge everyone not to disclose their private and confidential information. If you do have any specific legal questions, or if you're in crisis, or if you are facing a life-altering situation, such as a personal injury, I would strongly encourage you to seek legal advice. You may contact my office and I will be happy to help you with your case. So that's the disclaimer there. Moving on to the presentation itself, personal injury. So generally speaking, injuries can happen in many different ways, be it a motor vehicle accident or a medical malpractice, sort of injury, or a product liability or premises liability injury, or a workplace accident, intentional tort, wrongful death, all of those kind of injuries. And one of the injuries is slip and fall injury. So essentially, slip and fall cases are a subset of personal injury matters. And some of the most common causes of slip and fall cases involve poor maintenance of the property by the property owner. And keep in mind that there may be situations where the property owner may not be at fault, but in most cases, negligence plays a very, very important role. And so the most important question that you ask in personal injury cases is whether or not the property manager or the owner or any other person who's responsible to maintain the property, whether or not that person was negligent in identifying the hazards and removing them, or warning people about the existence of those hazards. So law imposes a duty on the property owner, the occupier, property manager, people who are responsible for maintaining the property, to maintain it in reasonable conditions, ensuring that any visitor that visits the property is safe. And when a property owner knows that there is a potential hazard and does nothing about it, then the injuries caused by that hazard can lead to a slip and fall injury claim. So that's important to consider. That's a very important question to ask. As I said, there can be multiple causes. Some of the examples are cracked sidewalks or tiles, or icy sidewalks, or you could have wet floors without any sort of warning. You could have torn or damaged damaged carpeting, broken floorboards, or improper handrails. So those are the kind of causes or negligence on part of the property owner that can cause certain injuries. Moving on to the next slide, I'll just very briefly talk about injuries. So it's important to understand here that if you've been involved in a slip and fall accident, it is not only important to delve into the true depth of your injuries, but it's also important to assess how those injuries will affect your life. And in most cases, it is not easy or straightforward to make that assessment. There might be ongoing chronic pain resulting from injuries, and that may affect the quality of an injured person's life. And sometimes it cannot even be fully anticipated. Sometimes the injuries can be extremely serious, such as head injuries or spinal cord injuries, and that make it almost impossible in some cases for some injured people to even return to work. And then in some cases, there may also be serious psychological trauma arising out of an injury. So those are certain injuries that are serious. Other examples could be broken bones, fractured bones, soft tissue injuries, back injuries, and depending on the nature of the slip and fall incident, victims sometimes may also suffer from other symptoms, and other symptoms include chronic pain that goes on for many months, even after the incident, even years. So chronic pain, migraine issues, sleep disorders, and even sometimes it can cause problems to internal organs. So those are some of the other examples of injuries. And these become more serious in case of vulnerable or disabled people. If disabled or vulnerable people, such as elderly, are involved, then a slip and fall injury can have more serious consequences. Also, in a lot of cases, medications, physical and psychological therapy, or any surgeries that these individuals may undergo, those can also have a major impact on the life of an injured person. So that's important to note. It's very important to understand the true depth of the injury. And at the same time, it's also important to understand how that injury is going to affect the life of the individual who suffers that injury. In certain cases, it may also affect caregivers. So in those cases, there is a possibility to make an FLA claim, which is basically basically a family member who is a caregiver also suffers damages. That person can also become a claimant in such cases. And so, as I mentioned, different kinds of injuries, there is this whole spectrum. So needless to say, whether your injuries are mild or severe, it is always very, very prudent to consult a lawyer so that proper assessment of your case can be done. And that will allow your lawyer to help you recover adequate and appropriate compensation. So that is very important. It's important for you to reach out to a lawyer so that proper assessment can be done. And then the lawyer can ensure that you get the justice that you deserve, that you get proper compensation for your injuries, for how it has affected your life, your work, your housekeeping, the general quality of your life, considering all of your injuries. So that is key. I'll move on to also discuss liability in these kind of cases. And this is one of the most important parts of my presentation too. Please bear in mind that in Ontario, slip and fall cases, they fall under the Occupiers Liability Act. And this is the law, this is the act that establishes the legal duties and responsibilities of occupiers of premises. So these people are either owners of property or property managers or individuals responsible for maintaining property. In some cases, these are also contractors. So they have these responsibilities towards visitors or individuals who enter the premises or the property. And it is incumbent on these individuals to maintain a safe environment and also warn the visitors of any potential hazards. Under the Occupiers Liability Act, an occupier is defined as a person who has possession or control of the premises, or someone who has responsibility for and control over the conditions of the premises, the activities conducted on the premises, or the persons allowed to enter the premises. So that's a very holistic definition of who could be liable, who could be defined as an occupier. And that is a definition that is a very key element of the law of personal injury, especially in slip and fall cases, because that determines who exactly is liable. It enables us to put the onus on that individual. It's important to identify who the occupier is and who is responsible. So this is what the Occupiers Liability Act provides us. And therefore, in accordance with this definition, an occupier may be someone who, as I said, manages the property. It could be a commercial property. There can be private property owners. There would be landlords. All of these people are responsible for maintaining the premises. And the liability issues will usually arise depending on different factors, and also depending on how and where the accident occurs. For example, if you look at commercial properties such as restaurants or stores or bars, commercial property owners, they have the obligation to keep the premises safe. And so when we look at slip and fall cases in these kind of premises, we usually see that injuries occur on commercial properties due to wet floors, or sometimes defective, broken, or uneven tiles, or even unsafe construction work without any warnings. And that's key, that's important. You must understand that if there is a potential hazard and then there is no warning, that in a way enhances the liability of commercial property owners or occupiers. Other factors in commercial properties may be, and these are the factors that can enhance liability as well. For example, poor lighting, or in some cases, failure to maintain parking lot that is attached to the property. So those are examples of slip and fall cases and the factors that enhance liability in these cases as far as commercial properties are concerned. Other than that, of course, private property owners, they also have an obligation to keep the premises safe. And so they must take every precaution to ensure that their home, their premises does not pose a risk to visitors. For example, they must clear their driveway of ice and snow so that it is safe for people to use. And that includes strangers like salespersons or repair workers. In some cases, even landlords are responsible for ensuring that their rented property is properly maintained. And this means that the tenants in the rented properties may be able to hold their landlords responsible for certain slip and fall accidents that occur on rented properties. And then some common slip and fall injuries also involve improperly cleared roads and sidewalks, which are, especially that happens during the winter months. And under Ontario law, municipalities can be held liable for a person's injuries if a sidewalk or road was not properly cleared or maintained. So this liability will also extend to other government properties, such as government buildings, sidewalks, public transits, airport terminals, even parks. So very, very broad-based. This duty is very broad-based, and it is a duty of the occupier and the owners and the managers to make sure that the property is safe for use by the visitors. Some of the legal principles that are used in assessing liability in slip and fall cases are duty to care, breach of that duty, and causation. And I'll explain that in a bit. So as I mentioned already, that in slip and fall cases, liability depends on several factors. that includes circumstances of the incident. It includes actions or negligence of the occupier, but also sometimes the actions and negligence of the injured party themselves. Sometimes there may be contributory negligence where the injured party maybe is not wearing proper shoes or did not take reasonable care. So that is an important aspect of identifying who is liable and to what extent. But primarily, liability involves these very important principles. One of them is the duty to take care, the duty of care. So the occupier owes a duty of care. This means that the injured party must prove in the court of law, they must show that they were lawfully present on the premises, that there wasn't any sort of trespass, they were lawfully present there, and they had a legitimate reason to be on the property, on the premises. And the occupier owed them a duty of care to maintain a safe environment. So that is the number one step. That is the most important factor, that there has to be a duty of care, and that has to be proved by the injured party that there was a duty of care. And then secondly, the injured party must also demonstrate that the occupier failed to meet the duty of care that was owed to them. That is key, that is essential. So this could, for example, include failing to address a hazardous condition or neglecting to provide a warning of a known danger. So that is an example of breach of duty. And then lastly, it is equally important to establish causation, which means that the injured party must establish that a breach of duty by which the occupier directly caused their slip and fall injury, that there was a breach of duty and that was the cause of the slip and fall injury of the injured party. So at the same time, it's also important to note that each slip and fall case is unique, and liability determinations depend on many facts. They depend on evidence, what kind of evidence is presented in the courts. So the courts will consider various factors. The courts will look at the condition of premises. The courts will also look at what were some of the actions taken by the occupier to address potential hazards. The court will also look at whether the injured party, as I mentioned earlier, contributed to their own injury through their own negligence. For example, not wearing proper boots, not being equipped, or not being careful, or not looking, or those kind of things where the injured party could have been prudent, could have been more careful, but was negligent. And so that is an element of contributory negligence where the court looks at that's one of the factors that the courts look at. Moving further and discussing liability in a little bit more detail, it is very important to note this very specific provision of the Occupiers Liability Act. It says that an occupier of a premises owes a duty to take such care as in all circumstances of the case is reasonable to see that persons entering on the premises and the property brought on the premises by those persons are reasonably safe while on the premises. So if you see reasonableness, that is the test. It is very important to understand that the law does not impose strict liability on the occupiers. Even though the language of this provision seems to be very straightforward, very simple, it leads to a few misconceptions about this provision. And a lot of times litigants think they are under this misconception that the occupiers are strictly liable for any slips and falls that will happen on their premises. And that is incorrect. The test, as I mentioned, is that of reasonableness. So as long as under the Occupiers Liability Act, the occupier has taken reasonable measures, has taken reasonable care, not perfect care, as long as they have taken reasonable measures and reasonable care to maintain the property, there may not be any liability. So to prevail on an occupier's liability claim, to have a personal injury claim, it is important that the plaintiff or the injured person must prove that the defendant was negligent, and was negligent in an unreasonable manner, that they did not take reasonable care. It's not perfect care, it's reasonable care. That's the test. And the second thing that they must prove is causation. So even if an occupier fails to meet the reasonableness standard, a plaintiff must still prove that the failure caused his or her injuries. So that is important to remember in such cases. Now, what exactly is reasonableness, and how do courts determine if a conduct is reasonable, if the occupier has fulfilled his or her legal duty? So in slip and fall cases, occupier liability cases in Ontario, reasonableness would refer to the standard of care that is expected from the occupier of a premises to prevent injuries to individuals who enter the property. And so it is incumbent on occupiers to take reasonable care to ensure the safety of visitors. And in this context, reasonableness would be defined as, or would be understood as, taking adequate and appropriate measures involving considering various factors, such as whether the property was being properly maintained, did the occupier maintain the premises in a reasonably safe fashion, for example, doing regular inspections or undertaking regular repairs. If they can see that there is a potential hazard, did they reasonably identify it and carry out reasonable repairs of the premises so that they could address the potential hazard? Other things such as warning signs. Did the occupier make an effort, or did the occupier provide a clear and visible warning to the visitors of any known dangers, such as wet floors or uneven surfaces or slippery sidewalks? It's not applicable in slippery sidewalks, but uneven surfaces is one example, or wet floors specifically. That's a very good examples where you should have those warning signs. Another factor that could be considered by the court is a previous incident. So did the occupier have knowledge of previous slip and fall incidents on the property? And if they did, were they able to take appropriate measures? Did they take actions to prevent similar accidents? So that is another factor that the court may look into. And at the same time, other factors like cleanliness. Is the premises reasonably clean? Is the premises reasonably free from any hazards that could cause slip and falls, such as any spills or any debris or any construction materials? So that is important too. And then, of course, the courts also look at industry standards, right? And they look at, for example, did the occupier adhere to recognized industry standards and best practices for maintaining the safety on their premises? And last but not the least, they will also look at the visitor's awareness. And this is something that I've pointed out earlier as well, because this leads to issues of how the visitor or the injured person is also liable. Did they contribute to their own injuries? Were they reckless? Were they negligent? Were they not wearing proper boots? Were they not taking enough care? Was the hazardous condition open and obvious to them? And if it was, then what measures did they take to protect themselves? Did they exercise reasonable care and caution? Because visitors also have this responsibility to exercise reasonable care and caution for their own safety. So those are some of the factors that the courts will look at. But to define reasonableness, I would say that reasonableness is different in each case. It is going to be very fact-specific. It's a fact-specific analysis, and it considers the circumstances and the evidence presented. But the courts will usually look at what a reasonable person would do under similar circumstances. So that's really the test. What would a reasonable person do in similar circumstances? And that is how they would assess whether the occupier actually met that duty of care. So that's how liability is determined in these cases. It's not as simple and straightforward, but those are some of the factors that the courts will look at. So that's about liability. Moving on, I would also touch upon, and this is very, very important to take note of, because this is like a checklist of what you need to do if a slip and fall incident occurs, and if you're involved in a slip and fall incident and you sustain injury. So what are the things that you should keep in mind? Of course, first and foremost, get medical attention, get immediate medical attention. Next, make an incident report. You must gather all the information that you have and make a note of how the incident occurred, when the incident occurred, who was present there, were there any witnesses, how did you seek help, did an ambulance arrive? So basically all the records, all the basic records regarding the incident, regarding how the incident occurred and what was the exact location or the time, or even identifying who could be the occupier of the premises. So that can be a very important component of an incident report. And this is very relevant when you are actually making a claim. It's very prudent to kind of gather evidence, start gathering evidence, such as soon as practicable, as soon as possible, getting security footage camera. So that footage is important. That could be your evidence, and that could show how the incident actually occurred, or any photographs that are dated from the date of the incident. Witness information, who was present, did someone help you, were there other witnesses who saw the incident happening, all those kind of all that kind of information is relevant. And as I also mentioned earlier, incident report will include even identifying who the occupier was, or who is the property manager, who was responsible for maintaining the property. Was there a contractor who was responsible for clearing the snow or ice from the premises? So that's all included in the incident report. It's equally important, I believe, to have all your damaged objects, for example, damaged clothing from the incident, and also what kind of shoes or boots were you wearing at the time of the incident. That is key, because if your boots were proper, if you're wearing proper shoes, that shows that you were taking proper care and you were not negligent. So that goes a long way in proving that the incident, or the slip and fall incident, or the accident happened for no fault of yours. So that is key as well. And at the same time, I would say that it is very, very important to document your injuries. Sometimes it's nearly impossible to anticipate or predict with precision as to what is going to be the long-term effect of those injuries on your life. How is it going to affect the quality of your life, or how is it going to affect your work, your employment? But it's important to make note of those things and make proper records, create a file of all your medical treatments, the treatments that you have been undergoing, your out-of-pocket expenses, the documents, such as your employment records. All of those things are relevant. To have them in one place will really help your lawyer to assess your claim properly and ensure that you are given you get justice for your injuries, and then you get properly compensated. One of the things that you could also include is the weather report. So that is also key. So that's the kind of information that you must keep with yourself. And of course, one of the most important things, what to do: seek legal advice. as soon as possible, as soon as practical, you must seek legal advice, because it is important for you to remember that your lawyer will be in the best position to not only assess liability issues, but at the same time, quantify your injuries. At the same time, quantify your injuries in terms of monetary loss, the compensation that you deserve. And your lawyer would also have information about the applicable limitation period. So for most lawsuits, the limitation period is 2 years. So you have 2 years from the date of the slip and fall to sue the party or parties responsible, but you must also notify them as soon as possible of your intentions to bring a court action against them. And it is also important to keep in mind that if you fall on city property, in some cases it may require you to notify the city of the accident in very little time, sometimes as short as 7 days. So that is the reason why it's very important for you to seek legal advice as soon as possible, because your lawyer would know the notice requirements, your lawyer would know the limitation period that is applicable. And one recent significant change that has happened in the recent past is this Ontario's Bill 118. Now, this is an act to amend the the Occupiers Liability Act, and it basically provides that no action shall be brought for the recovery of damages for personal injury. Now, this is related to snow or ice, basically slip and fall cases due to snow and ice. So no action shall be brought for recovery of damages for personal injury caused by snow or ice against a person or persons listed in subsection 2. And the persons listed in subsection 2 are basically the contractor and the occupier, unless within 60 days after the occurrence of the injury, written notice of the claim, including the date, the time, and the location of the occurrence, has been personally served on or sent by registered mail to at least one person that was listed in subsection 2. So this is a recent change that has happened. So there is this 60 days requirement of written notice of the claim. And so that is the reason why you must seek immediate legal advice. As much as it's important to seek immediate legal assistance, I would say the next best step is to seek immediate legal assistance at the same time, so that your lawyer can not only assess your liability, the liability of the other party, or any contributory negligence on your part, but the lawyer can also assess your damages. The lawyer can also quantify your injuries. The lawyer can look at your lifestyle, how your injuries have affected your life, and has this injury also affected your family members? So how do you quantify that claim? And then any limitation periods, if applicable, any notice requirements, that is important. In most of these cases, I would say it is very hard to specify or pinpoint the amount of compensation. It will vary on so many different factors. The amounts will range. For minor injuries, the amounts are going to be different. For catastrophic injuries, the amounts are going to be completely different. Sometimes they even go into millions of dollars. For example, for a fractured hip, the average slip and fall settlement would probably range around $500,000, but the amount might go up in certain cases if the individual has sort of sustained multiple physical injuries, or the injuries are also result in chronic pain. Even in cases of concussions, settlement amounts might be different and may increase in those cases. Again, psychological impairment, psychological trauma, that is also another factor that can increase the amount of compensation. So each personal injury case is very different, and the settlement is also different for every personal injury case. There are multiple factors ranging from liability to negligence of the injured person, to various factors that enhance the liability of the occupier, to the kind of injuries that are sustained, whether they're minor injuries or severe injuries, brain injuries, spinal cord injuries, the vulnerability of the parties. All of those factors are looked at, and that is how you assess the whole matter, the whole case holistically. It is not possible to pinpoint what will be the quantum or what is the compensation that you will get for a slip and fall case, but it is very important to seek legal advice early on, as soon as possible. As I said, immediate legal attention and immediate medical attention and immediate legal help or legal advice as well at the same time. So that pretty much summarizes this presentation, covering limitation periods and liability, and what are the steps you must take if you're injured. That pretty much summarizes the basic and general information on as far as these personal injuries, specifically the slip and fall cases, are concerned. And I'm open to any questions that you may have about this presentation.
Well, thank you very, very, very much, Manpreet, for this fruitful presentation. We do have actually some questions. I'm receiving quite of them all over the social media channels and over our messenger on Facebook. So one of them said, what if I do have insurance or OHIP? Would that affect my lawsuit if I am insured person or I'm covered by the OHIP? Would that affected my lawsuit if I slip and fall?
So your OHIP will cover certain medical treatments, but in a lot of cases, not all medical treatments may be covered by OHIP. So you can still claim damages for out-of-pocket expenses. You can claim damages for any psychological trauma as well. Anything that you have additionally incurred can be included in your damages, and you can claim compensation for that. So I wouldn't say that just because you are covered under OHIP or received insurance, I wouldn't say that that precludes you from making a claim. I wouldn't say that you will not receive additional compensation over and beyond it, because if you look at the concept of compensation, it's not necessarily only directly related to your injuries. It encompasses how your life is also affected because of your injuries. Sometimes it's practically impossible to even anticipate how a certain injury is going to affect the quality of your life in future. It could affect your ability to work, your ability to return to work, your lifestyle, your housekeeping, your scope of how you are going to make income in the future. So this is to be looked at in a very holistic manner. It's not just claiming compensation for the medical expenses that have been incurred or your treatment cost. It goes over and above that and beyond that and looks at the situation holistically.
Thank you very much. So another related question, actually, what if I get slip and fall at my work? Will that be considered as a claim against my employer, or that would be under the WSIB?
So if your employer falls under certain category, then it's going to be a WSIB claim. But if your employer does not fall, so first and foremost, it is your employer is also mandated by law to maintain a safe premises, to ensure that your working conditions are safe. So your employer has that onus to prove that the working conditions were safe, the premises was safe, necessary measures were taken to ensure that the premises were safe for all employees to work. If there were any hazards, they were very clearly identified. There were warning signs. It was, so that's number one. So if you are injured at work, you will, of course, be covered under WSIB. There are certain cases where you can go over and beyond your claim under it goes beyond your employment, and you can make an additional claim as well if other, so if it's within the scope of your work, if it's within the scope of your employment, your employer is largely responsible. Let's say you're not within the scope of your employment. You finished work, you're outside work, and this is not you're doing an activity that is not within the scope of your employment, or you are in a parking lot that is not maintained by your employer. In those cases, it will fall outside their scope. But as long as it is on their premises, even including the parking spaces that are maintained by the employer, your employer will be responsible. So that in those cases, it will be covered under WSIB.
I see. Okay, so another question. I slip and fall in the main street nearby someone sidewalk. Would that be a case against the municipal or against that person who owned the house which is attached to the sidewalk?
So that's a good question, and there is no straightforward answer. If the sidewalk belongs to this individual who owns the property, if they are legally responsible to maintain the sidewalk, if it's within their premises, then it's the owner of the property or the occupier of the property. But if this is a sidewalk which falls within the jurisdiction of the municipality, and the person, the home adjacent or the house adjacent to the sidewalk, if they are not responsible for maintaining the sidewalk, then it will be under municipality, it will be under the jurisdiction of municipality. And so municipality will be liable for such a slip and fall case.
Thank you. So another question, could you provide more information about different limitation period for slip and fall accidents?
Yes, generally speaking, the limitation period is 2 years. It's consistent for most lawsuits. You have 2 years from the date of the slip and fall, and from that date you can sue the parties. You can bring a claim and sue the parties that are responsible. But it is also necessary in some cases to notify them as soon as possible of your intentions to bring a court action against them. So for example, in some cases, if you fell on city property, you may have a very short limitation period in the sense that you must notify the city of the accident or of the slip and fall incident in as little as 7 days, for example. And very recently, and I think I did cover this in my presentation as well, there has been a recent change as well that you must notify the occupier within 60 days after the occurrence of a slip and fall injury, which is caused by snow or ice. So that requirement is relatively new. A written notice must be sent out. This written notice must include the claim, the nature of claim. It must include the date, the time, and the location of the occurrence, and it should be personally served on the individual responsible, or it should be sent by registered mail to at least one person who is an occupier, either an occupier or a contractor who was responsible. So that is a new requirement as well, and that is the reason why I do emphasize that when such a situation occurs, when there is an incident of this sort, it's very important to seek legal advice, because generally speaking, the limitation period is 2 years, yes, but the law is also always constantly evolving. The law is not static. It does keep pace with changing dynamics and the changing requirements of the society. It's organic, it's growing. And so your lawyer will be in the best position to know as to what requirements apply to your specific case. If it is a case involving city or municipality, there might be different requirements, and a notice has to be sent almost within 7 days in most cases. If it is a case that involves snow or ice, there's a different requirement where you need to send this notice within 60 days. So it's important to seek legal advice at the outset and prepare early on. Make sure that you get the best legal advice right at the outset so that you don't miss out on limitation period. Generally speaking, it's 2 years, but then there might be certain specific situations where there may be some notice requirements as well.
Okay, thank you. Well, last but not least, it's, a little bit of legitimate question, but it's also, why is it taking so long for the slip and fall cases in the courts? Why it could be taking years?
Well, that's I can understand the frustration of litigants. I can understand that there are some delays, but that's more of a systemic issue. That's how the legal procedures function, and sometimes it's not. You cannot pinpoint one particular cause for delays. Sometimes the opposing parties may not be able to provide you the relevant documentation that is needed to move your file forward. Sometimes you need to bring multiple motions just to get all of the documents in place and collect all of the evidence. Sometimes you need your employment files and your medical records and your treatment chronologies, and you need to collect all of that information, and that process itself takes time. So sometimes it's those kind of delays. But then there are times where there are certain systemic issues that play an important role too. For example, right after the pandemic, we did see that there was a significant backlog. And so the cases and the files were moving slowly because the courts are addressing those backlogs. And so that basically causes delays and it's not limited to slip and fall cases. It's not limited to specifically slip and fall cases. It's just a general observation that there are some delays due to some systemic issues. And so those are things that usually are beyond the control of lawyers. Sometimes some of the things are within the control of your lawyer. They can always expedite the file. They can always seek undertakings or documents and whatever documents are necessary to prove your case. So those are the factors that may cause delays in some cases, but some could be avoidable. Some are totally unavoidable. Some are beyond the control of individuals.
Well, it seems we don't have any other questions yet. Oh yeah, we've got one. So are the occupiers obligated to provide me with the evidence they have that supported my case, even though it could be used against them?
See, the law mandates that there should not be any trial by ambush. So if the occupier has any relevant information, they are bound by law to provide you that information. And if they have not provided you that information, then they cannot rely on that information later on to escape liability or to limit their liability. So law provides for a mechanism where you have this whole procedure established where you go through this process of examinations for discovery. And that's essentially the process when you discover the opposite party and you kind of dig deep and find out what kind of evidence they may have in your matter. So probably one of the common examples that I can recall, and one of the files that I worked on was involving video footage. So you can most certainly ask from the occupier to provide you that video footage. If the occupier refuses to provide you that video footage, you can of course seek legal help, and there are methods and ways and means that the lawyer while this whole process is underway, can ensure that all of the relevant documents, the footage, the photographs, the evidence, witness information, all of that is provided to you. You are legally entitled to have that information, even if it goes against the occupier. They cannot deny providing you that information. And that is why we have this additional step where examinations for discovery allow you to explore the case in further detail. It allows you to examine the opposite party and examine what their stand on, what was their version of the events that transpired, what are the documents that they have in their possession, and you can always ask them to provide those documents, obviously within reasonable limits. Usually these are, for example, employment records. In certain cases where you're looking for employment records, you usually look for a certain time period, or medical treatments. So they might ask you for certain documents. They might ask you to provide medical records 3 years prior to the accident and 3 years after the accident. So there are those kind of limitations. And then you, as an injured party, can ask them to provide video footage or photograph or witness information or any other relevant document that they may have in their possession. And that is your legal right. If they are not providing you that information, they can, there are many mechanisms. A motion can be brought in the court. And so those documents, depending on how relevant they are, that can be made accessible to you.
Thank you very much, Manpreet, for all of this information. It seems we don't have any other questions, so this will bring us to wrap up this interesting and fruitful session. Thank you very much. It was an honor to have you here with us, and thank you for all of that information.
You're very welcome. It's my pleasure to be here.
Thank you. Okay, everyone, thank you very much for being here today, and we are looking forward to see you at another session with Rights and Responsibilities Awareness Initiative. Stay safe, stay well. Bye-bye.